Our keynote speaker is Annette Gordon-Reed. She's professor of history and law at Harvard University. She's a winner of the MacArthur Fellowship, which is often nicknamed the MacArthur Fellowship for Genius. She's a fellow of the American Academy of Arts and Sciences. She's published 6 books. The first one, which was a biography of Andrew Johnson, but perhaps one of her most famous was on Thomas Jefferson and Sally Hemings, An American Controversy, and for some reason she always likes to hear me pronounce that word. And the book, though, that won the most awards was The Hemingses of Monticello, An American Family. It won both the National Book Award and the Pulitzer Prize. It's said today that Sally Hemings is America's best-known African-American woman, and in large part that is due to Annette Gordon-Reed. Her most recent book, An American Patriarch, is co-written with Peter Onuf, a fascinating series of essays which really try to give insight into the private character of Thomas Jefferson. I have to say that she's been a tremendous friend to Monticello. She actually opened our visitors center, and I had been unaware of the date that that opening would take place and had organized a conference in Australia. She went straight from opening the visitors center, got on a plane, and went to Australia to speak at our conference. And she's done incredible work on behalf of the foundation and has also really helped us to think through how you present Jefferson in a balanced light while taking account of the 600 people who were enslaved at Monticello. She introduced me some years ago when she was the Harmsworth visiting professor at Oxford, and I gave the Sir John Eliot lecture. And so I'm delighted to be returning the favor today. I used to have a colleague who'd introduce people like Gerda Lerner, who she thought was some of the really great historians of our time, as a national treasure. She's certainly a treasure to us, but I think a national treasure as well. Please join me in welcoming Annette Gordon-Reed.
Thank you very much for that introduction, Andrew. I just got a message from Peter Onuf. He will be here tomorrow. He's just arrived in Richmond, and he will make his way here. I'm sad that he's not here, but in another way I'm sort of glad, because I've actually written out a speech, which I never do, and people who know Peter knows that he hates that, the idea of anybody writing anything out, but I decided I would go ahead and do that. So it's good that he's not here to see this. But I do miss his presence. First off, I should say that the title of this talk that's in the program is not exactly what I'm going to talk about. Jefferson and Hamilton will be in the talk. Courts will be in the talk, but it's not about the two men's specific relationship with judges or courts. Now, both men were lawyers who had extensive experiences with judges and courts, but I want to talk about their understanding of the role of courts and the judiciary as in general in the government that they helped to create. I will spend some time talking about both of them. As it turns out, I'll spend some more time talking about Hamilton, and I think this is because his views about the subject were put in the Federalist, and that is a document that has become iconic, and people talk about it, law professors in particular, and his views are much more known than Jefferson's, than by lay people and members of the public, I would say. So we know Jefferson's views about judicial review, for example, because of Marbury v. Madison and his great fight with John Marshall. But most of the time, Jefferson is talking about courts, it's very private, and so people don't know those kinds of things, although his characterization of Marshall's twistifications in a letter to James Madison is imperishable, and it's one of my favorite Jefferson quotes. I think it's safe to say when people think of Jefferson and Hamilton, they think about their great rivalry in the 1790s, when they were at each other's throats, when they were in the cabinet of George Washington. But it's usually about politics in relationship to the executive and the legislature, not so much about the judiciary, and there's a good reason for that. They talked about the extent of presidential power, they argued about the extent of presidential power and the extent of legislative power, and they had different opinions about that. That they should have trained their attention on these two subjects makes sense, given that those two branches of government, during the early years of the Republic, when they were contending with one another, were the most important and the most difficult, most active. As scholars have noted, the Supreme Court, in extreme contrast to the situation today, was really sort of the poor relation in the frame of government created by the Constitution. The members of the court didn't even have a proper quarters in the building, in the first federal building. The justices worked in mean conditions. They had to ride circuit in a very, very difficult manner, and it's a very, very strenuous kind of job. And it took a lot to get people to want to actually be on the court. You think about now, people will suffer anything to be on the court, literally anything to be on the court, but then people were not so sure about it. They were much in the background during this time period. Indeed, the original idea of having a Supreme Court, a federal Supreme Court, had been adopted with little discussion, though there were some concerns about the issue of the court having the power to decide the constitutionality of provisions as they interpreted the law. John Dickinson said that he thought that no such power should exist, but he admitted that he was at the same time at a loss at what expedient to substitute. James Madison raised a similar concern in 1788 about making, quote, the Judiciary Department paramount in fact to the legislature, which was never intended and could never be proper. The concerns turned out to be largely theoretical at first, given the relative weakness of the court during this time period. They simply did not have that much to do. On the other hand, the President and the Congress were dealing with lots of issues. Now, the problem that Madison and Dickinson identified has been with us until this very day. How do we uphold the rule of law without having the Supreme Court or any among the inferior courts, federal courts, such act as a super legislature in a fashion that is considered anti-democratic? On the other hand, how does one check the power of majorities who would do violence, real and metaphorical, to the lives and fortunes of unpopular minorities? One could understand that despite some misgivings about the nature of judicial power, that there was no reason to fear that the newly created Supreme Court or inferior courts would act in a way that they might fear a president would act, becoming akin to the discarded George III, or the 173 despots that Jefferson talked about in Query 13 of Notes on the State of Virginia, when he was talking about the dangers of what he called elective despotism, when he was talking about the Virginia Constitution of 1776. Now, he was speaking in a different context, but the idea, the concept is still applied to the action, or could be applied to the actions of a federal legislative body. Alexander Hamilton's Federalist 78 is perhaps the most well-known statement about the powers, or relative lack thereof, of the judicial branch of government. As you know, it was part of a series of essays crafted to defend the proposed judiciary against attacks by anti-federalists. In Hamilton's view, one of the chief functions of the judicial branch was to keep the legislature in check by assuring their adherence to the Constitution, which was itself a limit on the powers of government. On the subject of judges and power to opine on the legality of statutes and serve as a bulwark against legislative overreaching, Hamilton speaks the words of practicality, writing, "Limitations of this kind can be preserved in practice in no other way than through the medium of the courts of justice, whose duties it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing." He also says, "The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as fundamental law. It must therefore belong to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation ought, of course, to be preferred. In other words, the Constitution ought to be preferred to the statute, the intention of the people, to the intention of their agents." In perhaps the most famous passage of number 78, Hamilton goes straight to the heart of the question of power and the judiciary. "Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its function, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments." Now, from today's perspective, these sentiments appear quaint. But then we, especially we law professors, have imbibed some of the most basic teachings of the legal realists. The statements that courts have merely judgment is, of course, a decidedly pre-legal realist understanding of the role of the judge and courts in society, particularly in a society in which judges are appointed by the president with the advice and consent of the Senate. The president and senators are into politics. They are politicians. In such a world, judgments by courts, especially on controversial matters, are not mere. The realization that judges exercise power through their rulings, particularly when they're given the final say, that is, making the final judgment, is a definite pushback against the notion that the judiciary is inherently weak. Courts' exercises of power grow out of the nature of the society in which the judge is making the rules. Hence Holmes, Oliver Wendell Holmes' famous words from the common law. The life of the law has not been logic. It has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have a good deal more to do than the syllogism in determining the rules by which men should be governed. Holmes is credited with initiating the realist turn that transformed understandings of the law. Certainly, a system that sees judges appointed by politicians would necessarily be political. It was not for nothing that John Adams rushed to put in as many Federalist judges as he could in the waning hours of his presidency, or that Jefferson was thinking about what judges he was going to appoint well before he actually gets in office, thought very, very hard about whom he would appoint to the bench, making sure that they were judges with good Republican character. People at this time were not ready for the frank admission that judges interpret law and make law, guided by the context and social circumstances surrounding them. Law was supposed to be something different, something apart from what I should say, maybe mere politics, Hamilton and other members of the founding generation were part of a formalist tradition that would have been uncomfortable with the naked proclamation that judges exercise political power as they interpret law. This is why he would speak confidently and think people would believe him when he described the court as having mere judgment, a thing that did not measure up to the power held by the executive, the sword, and the legislature, the purse. It also must be said, however, that it was not actually in Hamilton's interest to admit that a proposed federal judiciary would be just another strong basis for the exercise of federal power in the new system. And think of the last part of Hamilton's famous quote about the judiciary, that it must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. That makes sense on the surface, and it made sense at the time Hamilton wrote it. This was before the United States had formed a nation under the Constitution, very significantly a nation under a written Constitution that created expectations about the meaning of law in the new republic, as well as rights. The written document created a contract between the people and the government, a people who did not have 1,000 years of built-up shared culture or a national religion. They had recently destroyed a symbol of continuity over the years by getting rid of the royal family and the concomitant system of aristocracy. Even more than their British cousins, the white colonists turned American citizens were law-minded people. The fixation on law and rights that would flow for them, that Tocqueville would note when he visited the United States in the 1830s, was put in motion with the ratification of the document of which Hamilton argued for so strenuously. The notion of the rule of law, of being a government of laws instead of men, was and is an enormously powerful concept. It guides behavior, whether individuals happen to be in a specific legal suit or not, telling people what they can and cannot do, and telling people what the government can and cannot do to citizens. The concept fosters restraint as well as delineating rights, a posture that has turned out to be enormously important in a diverse and dynamic nation, as described above, without any credible claim to having long-held blood ties or cultural cohesion or a singular religion. Now, I should be clear that I fully recognize that the cohesion created by the notion of the rule of law has often been breached. Extralegal violence of all types has been employed in the United States, particularly against disfavored minorities. But significantly, the objects of those breaches have turned to law to seek redress, both on a personal and a systematic basis, as they try to bring back this notion of restraint. Now, while it is true that courts don't have armies or money to spend on the polity, their power derives from the people's belief in the rule of law. Perhaps this is part of the, quote, spirit of the people, unquote, that Jefferson suggested was the true source of the power of republicanism in the country. The fact that a court's pronouncements renders a ruling that the majority of the country feels bound to obey, usually as a matter of course, without a required threat of violence, is evidence of tremendous power. Now, Hamilton was at the beginning of something, and obviously could not see how the country would be knit together, albeit imperfectly, through a belief in the importance of the processes of the law, expressed through the courts, that this would become a feature of American life. Nor could he have foreseen how the forces unleashed by democratic impulses would help to make the courts, particularly the federal courts, an engine for transformation in American society. Indeed, the judiciary, and all of us today are well familiar with the story of the 20th century judiciary and the role that the courts have played, have, as I said, been an engine of this transformation, for better or worse. And we can talk over the next couple of days about what we think about that. I'm thinking mainly about the civil rights movement. While it is true that the executive branches had to be called in sometimes, for instance, Little Rock is a famous example, the court's explication of the issues at stake and decision to come down on the side of bringing African Americans into full citizenship made a powerful statement for the role of law in our society. The people who opposed the changes were constructed as acting outside of the law. Who can look at the faces twisted by hate, yelling epithets at young blacks walking into schools desegregated by the order of the courts, and not see that? To be sure, the practice of relying on the courts to enact social change has not been without controversy or controversy, Andy. Nor has it all been in one direction. Think of the Lochner era of the late 19th century that was ended by FDR. And think of the Supreme Court likely to come, when there will be another transformation, it seems, in our understanding of law. And it may be in ways that the majority of Americans find disagreeable. But whatever one thinks of the proper role of the judiciary in a Republican society, there's no question that courts in the United States can no longer be considered the least powerful branch in government. The Anti-Federalist Brutus letters, which were the impetus for Hamilton's defense of the judiciary in the Federalist, apprehended the possible power of the Supreme Court and focused on another component of the court's power, the capacity to review the acts of Congress, the representatives of the people. He was not talking about how the attitudes about the courts and the law would develop over time, as I was speaking before, as a source of power today of the court, a thing that he could not have foreseen, obviously. He focused on the structure of the Constitution itself and the problem of judicial review. He saw the power as a, quote, defect, unquote, that gave the court, quote, immense power on an unparalleled scale. If matters proceeded as proposed, he said, there would be no power to control their decisions. In such a situation, and vested with full judicial independence, the new justices would feel themselves independent of heaven itself. Now, Jefferson echoed the concern in a number of letters. After Marbury v. Madison, the matter was not so simple. It was not an academic matter to him. Writing to Abigail Adams in 1804, not long after the case, Jefferson said, "The Constitution meant that its coordinate branches should be checks on each other. But the opinion which gives the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive, also in their spheres, would make the judiciary a despotic branch." He grew more and more strident on the point as he watched from the sidelines in retirement at Monticello as Chief Justice Marshall, basically in his effective effort to draw more power to the federal government, consolidated the Supreme Court's power. Jefferson was still sounding this theme in 1820. To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism, that word, despot, of an oligarchy. Our judges are as honest as other men, and not more so. They have with others the same passions for party, for power, and the privilege of their course. So Jefferson sounds almost like a legal realist. Their maxim is boni judicis est ampliare jurisdictionem. Good justice is broad jurisdiction. And their power the more dangerous, as their office is for life and not responsible, as the other functionaries are to the elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided, with the corruption of time and party, its members would become, again that word, despots. It has more wisely made all the departments co-equal and sovereign and within themselves. How to check these unconstitutional invasions of rights by the federal judiciary, he asked, not by impeachment in the first instance, but by a strong protestation of both houses of Congress that such and such doctrines advanced by the Supreme Court are contrary to the Constitution. And if afterwards they relapse into their same heresies, a favorite Jefferson word, impeach and set the whole adrift. For what was the government divided into 3 branches, but that each should watch over the others and oppose their usurpations? Just as people today would not be able to recognize current-day courts, particularly the present-day Supreme Court, in Hamilton's description of it as a weak body, they would not be able to see Jefferson's idea that each branch of government should be able to decide whether an act was constitutional. How would that work in the present system of government as it has developed over the years? At the time, the power of the court can be seen in the fact, at the same time, the power of the court can be seen in the fact that we basically have lots of elections that are carried on and people vote on the basis of who they think will be elected and how they will constitute the Supreme Court, knowing that these people have an opportunity to transform society in the ways that I was talking about before. That is a power that neither Hamilton nor Jefferson would have contemplated. We could and should ask whether it should matter at all. And after I've gone through all of this, does it matter at all? Is there any important purpose to be served by considering what Hamilton had to say about the nature of the judiciary in Federalist 78? Of course, Jefferson's vision of a tripartite power was to opine upon the constitutionality of a provision would be unworkable, though his concern about the implications of rule by 9 people in black robes resonates with many today. In the end, John Dickinson may have been right. Judicial supremacy may be a problematic concept, but no one to date has suggested a better alternative, although some in this audience may dispute that. Thank you. Do I have questions or no? Is that it?
Questions?
Or no?
Yes.
I think people want to go home. Sure. No questions? We'll wait for tomorrow? No, I think people want to go home. Thank you.